Mike thinks he's being helpful. The officer asks, "Do you know why I stopped you?" Mike answers honestly. He jokes. He explains. 5 minutes later, he's out of the car, hands on the hood, wondering how a broken taillight turned into cuffs. I'm a criminal lawyer, and I see this every single week. Traffic stops don't drag on because of bad luck. They drag on because drivers say the wrong things, at the wrong time, in the wrong order. In this video, I'll show you 7 simple legal tricks that keep traffic stops short, calm, and controlled without being rude, risky, or suspicious. Trick number 1. Do you know why I stopped you? Never answer the "do you know why I stopped you?" question. This question sounds harmless. It's not. In fact, it's one of the most strategically loaded questions an officer can ask during a traffic stop. When an officer says, "Do you know why I stopped you?" they're not asking for information, they're testing for self-incrimination. If you say, "Yeah, I was probably speeding," you've just admitted to the violation. That single sentence can be used to justify a citation, escalate the stop, or lock in probable cause. And once you've handed that over, you can't take it back. Here's the reframe you need to understand. Traffic stops are investigative encounters, not conversations. Every answer either narrows or expands the scope of what the officer can legally do next. Now here's the part most drivers miss. Even if you did nothing wrong, guessing is dangerous. Saying, "I think my taillight is out," gives the officer a reason to inspect the vehicle. Saying, "I might have drifted a bit," invites field sobriety questions. You're filling in gaps the officer may not legally be able to fill on their own. So what should you say? The safest, cleanest response, used by defense attorneys and law enforcement trainers alike, is neutral and non-admitting. "No, officer." That's it. Not sarcastic, not argumentative, just factual. Drivers who answer this question extend the stop by minutes. Drivers who don't often shorten it dramatically, because the officer must now rely only on what they personally observed, not what you volunteered. This isn't theory. Courts have repeatedly held that voluntary admissions during traffic stops are admissible evidence. The Fifth Amendment protects you from being compelled to incriminate yourself, but it does not protect you from talking yourself into trouble. The American Civil Liberties Union explicitly advises drivers not to volunteer information or admit guilt during traffic stops, noting that anything you say can legally be used against you later. Another critical point most people don't realize: refusing to answer this question does not give an officer grounds to detain you longer. Silence or a neutral response is not reasonable suspicion. It's a constitutional right. Bottom line, and this is what I tell my clients after the arrest they wish they avoided: the moment you answer that question, you've changed the stop. If you don't answer it, you keep control. Trick number 2, control the first 30 seconds. The first half minute of a traffic stop quietly decides how the rest of it goes. Not the explanation, not the paperwork, the first 30 seconds. Before you say a word, the officer is already assessing 3 things: threat level, cooperation level, and complexity. Your job is to signal low risk, low resistance, low workload immediately. Officers are trained to simplify encounters that feel predictable and safe. If the first moments feel chaotic, defensive, or talkative, the stop expands. So what does control actually look like? Start with your hands. Place them visibly on the steering wheel. Turn the engine off. Interior light on at night. These aren't submission signals, they're safety cues. When officers don't have to worry about what they can't see, they relax. And relaxed officers move faster. Next, don't reach for anything until instructed. Digging for documents before being asked triggers uncertainty. Uncertainty slows stops. It leads to extra questions. Sometimes it leads to you being asked to step out. Then comes tone, calm, neutral, short answers, not friendly chatter, not tense silence, just controlled responses. The officer decides in the first moments whether this is a warning stop or an investigation stop. You want to stay in category 1. Now the critical mistake: drivers think explaining early helps. It doesn't. Talking fast, over-explaining, or apologizing immediately raises cognitive load. Officers hear this as nervousness, not honesty. Nervousness leads to more probing. This is backed by training doctrine. The National Highway Traffic Safety Administration emphasizes that officer safety and situational control are primary during initial contact, which is why visible hands, clear compliance, and minimal movement reduce escalation risk. https://www.nhtsa.gov, road safety, traffic safety. Facts. Another authoritative source, the U.S. Department of Justice, notes that citizens are not required to volunteer information during stops, and that calm, limited interaction reduces misunderstandings that escalate encounters. Two drivers commit the same violation. One chats nervously and explains. The other stays still, calm, and brief. One leaves in 5 minutes. The other gets questioned for 20. This isn't about being clever, it's about being boring. If you control the first 30 seconds, the officer has less reason and less legal room to do anything more. Trick number 3, speak less than you think you should. Silence is not suspicious. Most drivers sabotage themselves by talking. Not lying, not arguing, just talking too much. In court, I've never seen a case made better by a driver's extra explanations, but I've seen plenty made worse. During a traffic stop, every sentence you add creates new material an officer can work with. You're not filling silence. You're expanding the investigation. What starts as a lane violation quietly becomes questions about where you're going, where you've been, whether you're tired, distracted, or stressed. Each answer opens another door. Now, the key misconception: people think silence looks guilty. Legally, it doesn't. You are required to provide your license, registration, and insurance. Beyond that, most casual questions are voluntary. You're allowed to answer briefly or not at all without it being reasonable suspicion. The safest approach is controlled minimalism. Answer required questions clearly. Decline optional ones politely. Stop talking once you've complied. Officers don't need your story. They need facts. When you offer narrative, you introduce inconsistencies, and inconsistencies trigger follow-ups. Think about this exchange. Where are you headed tonight? It's kind of a long story. That's how stops stretch. Instead, a professional response sounds like this. I'd prefer not to answer any questions. Not rude, not confrontational, just final. This isn't loophole lawyering, it's constitutional practice. The American Bar Association explains that individuals have the right to remain silent during police encounters, and that choosing not to answer questions cannot legally be used as evidence of guilt on its own. Another important point drivers misunderstand: silence doesn't escalate a stop. Inconsistency does. Talking increases the risk of misstatements, especially under stress. Stress changes tone, pacing, and memory recall. Officers are trained to notice that. The more you speak, the more you give away control. The less you speak, the more the stop stays narrow. Courts have consistently ruled that silence alone does not create probable cause. What creates problems is voluntary information that contradicts observable facts or raises new suspicions. Bottom line, and this is courtroom reality, not internet advice, silence isn't suspicious, it's discipline. Trick number 4, use polite, neutral language that signals low risk to the officer words. Don't just communicate information during a traffic stop, they communicate risk, and risk perception determines how long you're standing on the shoulder of the road. Officers aren't deciding whether you're nice. They're deciding whether you're predictable. Predictable encounters end faster. Polite, neutral language does one thing exceptionally well. It lowers friction, not by flattery, not by friendliness, by removing uncertainty. When an officer hears calm, respectful, non-emotional responses, they're less likely to slow the stop down with follow-up questions or safety checks. This does not mean apologizing. Apologies imply fault. Saying sorry about that can be interpreted as an admission, especially in traffic violations. That's a legal mistake dressed up as manners. So what does correct language sound like? Short, direct, neutral. Yes, officer. No, officer. I don't consent to searches. I'd like to remain silent. No sarcasm, no jokes, no tone shifts. Tone matters more than content. A correct legal statement delivered emotionally sounds defiant. The same words delivered calmly sound procedural, and procedural stops move quickly. Another mistake drivers make is over-friendliness. Joking, laughing, or oversharing doesn't relax the encounter, it complicates it. Officers are trained to notice behavioral changes. Forced friendliness can be interpreted as nervousness. Nervousness invites probing. Now let's address the myth. Being polite does not mean waiving rights. You can be courteous while asserting boundaries. Courts have repeatedly upheld that firm, respectful refusals are lawful and cannot be used as grounds for detention. The U.S. Department of Justice explicitly states that individuals may assert their rights during police encounters without facing retaliation or escalation, as long as they do so calmly and lawfully. This is echoed by the American Civil Liberties Union, which advises drivers to remain polite, keep statements brief, and avoid emotional language to reduce the risk of misinterpretation during stops. Drivers who stay neutral finish the stop. Drivers who add emotion extend it. Anger slows stops. Jokes slow stops. Explanations slow stops. Professional language keeps the interaction narrow, and narrow stops end faster. Bottom line, politeness isn't submission, it's a strategy. Trick number 5. Never consent to searches, even if you're innocent. This is where most traffic stops quietly turn into full-blown cases. Not because of contraband, but because of consent. If an officer asks, "Do you mind if I take a look?" it usually means they don't yet have legal grounds to search. They're asking you to give them permission they don't otherwise have. Consent changes everything. The moment you say yes, you waive Fourth Amendment protections. Anything found, even unrelated to the stop, becomes admissible. And no, you don't get to undo consent later because you felt pressured. Innocent people consent more often than guilty ones, and they get burned more often. Why? Because innocence doesn't stop mistakes. Officers can misinterpret items, smell something they think is suspicious, or discover issues unrelated to the original stop. A simple equipment violation can turn into a search, then questioning, then detention. So what's the correct response? Clear, calm, final. I do not consent to any searches. No explanations, no attitude. No, I have nothing to hide. That phrase is legally meaningless and tactically harmful. Here's the critical clarification most people miss. Refusing consent is not probable cause. It does not justify a search. It does not legally allow the officer to detain you longer just to wait and see. Courts have been very clear on this point. The American Civil Liberties Union explicitly advises drivers to refuse consent to searches, noting that officers may still search with a warrant or probable cause. But voluntary consent only makes their job easier, not yours. When drivers refuse consent, one of two things happens. Either the officer already has legal grounds, and the search happens anyway, or they don't, and the stop ends. In both scenarios, refusing consent never makes your position worse. Consenting often does. Another common trap. Officers may phrase the request casually to make it feel cooperative. Just a quick look. It'll only take a second. Those phrases are designed to reduce resistance, not protect you. Professional drivers and smart ones keep it procedural. Polite refusal. Neutral tone. No follow-up discussion. Bottom line, straight from criminal defense reality. If there's nothing to find, refusing consent costs you nothing. If there is something to misinterpret, consenting can cost you everything. Trick number 6, don't argue the stop on the road. Save it for court. This is where emotions cost people citations, searches, and sometimes arrests. Arguing roadside feels justified, but legally, it's the worst place to do it. You cannot win an argument on the shoulder of the road. You can only make the stop longer. Officers are not judges. They don't rule on legality in real time. Once the stop has begun, the decision to issue a ticket or warning is already moving forward. Challenging the reason for the stop doesn't reverse it, it escalates scrutiny. Drivers think they're standing up for themselves. What officers hear is resistance. Statements like, "That's not true. You can't stop me for that. I know my rights." None of these shorten a stop. All of them shift the encounter from routine to adversarial. The moment you argue, the officer slows down. More checks, more questions, more time. And here's the legal reality most people don't understand. Even if the stop was illegal, arguing on scene doesn't fix it. Courts decide legality later based on reports, dash cam footage, and evidence, not roadside debates. The correct strategy is simple. Comply physically. Preserve objections verbally for later. Document everything afterward. You can disagree without arguing. A professional response sounds like this. I understand, officer. That sentence doesn't admit guilt. It doesn't waive rights. It keeps the stop moving. Officers are trained to maintain control of the scene. When that control feels challenged, they expand the stop to reassert it, legally or procedurally. This isn't speculation. The U.S. Department of Justice explicitly advises that disputes over police conduct should be handled after the encounter through legal channels, not during the stop, to avoid escalation and misunderstanding. Courts repeatedly affirm this principle. Even unlawful stops don't justify resistance or argument on the spot. The remedy is suppression of evidence later, not confrontation now. Silence protects your case. Arguments create evidence. If the stop was wrong, court is where you win. If the stop was right, arguing only makes it worse. Bottom line, the road is not the courtroom, act like it, and the stop ends faster. Trick number 7, know the one sentence that ends most traffic stops faster. There is one sentence that consistently shortens traffic stops, not because it's clever, but because it resets the legal framework of the encounter. Most drivers never use it, and most arrests I see start before it's ever said. The sentence is simple. Am I being detained or am I free to go? This question does 3 things instantly. First, it forces clarity. Traffic stops often drift. What begins as a citation quietly turns into casual questioning, then probing, then delay. This sentence stops the drift. The officer must either articulate a legal reason to continue or allow you to leave. Second, it signals procedural awareness, not defiance. You're not refusing. You're not challenging authority. You're asking for status. Officers understand this language because it mirrors how courts analyze police encounters. Detention versus consensual contact. Third, and this matters, it shifts time pressure back to the officer. If there's no lawful basis to extend the stop, continuing becomes legally risky. Drivers worry this question sounds confrontational. It doesn't if delivered correctly. Tone decides everything. Calm voice, neutral expression, no attitude. You're not demanding, you're clarifying. If the officer says you're free to go, the stop ends. If they say you're being detained, they've now committed to a legal justification, one that can later be challenged. That's the leverage. Here's where people mess it up. They ask too early or too aggressively. You don't lead with this. You wait until documents are returned or questioning becomes repetitive. Timing turns this sentence from effective to suspicious. Courts have repeatedly confirmed that citizens may ask whether they are free to leave without creating reasonable suspicion. The American Civil Liberties Union explicitly advises using this exact question to determine whether a police encounter is voluntary or a detention. This isn't a magic phrase. It doesn't override probable cause. If the officer has legal grounds, the stop continues. But when they don't, this sentence ends it. In real defense work, this question often marks the moment a stop stops growing. No more fishing, no more casual probing, just a decision. Bottom line, most drivers wait for permission to leave. Smart drivers ask whether they already can. If you remember one thing from this, remember this. Traffic stops are not conversations. They are legal encounters. The faster you recognize that, the safer and shorter they become. You don't need to be rude, clever, or confrontational. You need to be calm, disciplined, and precise. These 7 tricks are the same principles criminal defense lawyers rely on every day to protect their clients after things go wrong. Except you can use them before that happens. Keep watching this channel for more real-world legal guidance that helps you stay out of trouble, not fight it later.